the Hindu editorial of the 26th of August 2024. The first article is Reality of Real Life Exploitation as a Structural Problem. This is written by two people, Kaleshwaram Raj, a lawyer at the Supreme Court of India, and Tulsi K. Raj, also a lawyer at the Supreme Court of India. The article goes, the Justice K. Hema Committee report, which was released by the Kerala government on August 19, 2024, has ignited a debate on the issues faced by women in Malayalam film industry. The committee, which was formed in 2017, had submitted its report to the government in 2019. A redacted or shortened version of the report has now been put up in the public domain. Though it addressed the issues faced by women in the vernacular films or language films, the issues transcend these boundaries. Broadly, the report deals with two categories of issues. The first is the sexual exploitation of and assault against women in cinema. The report says that women are often required to exchange sexual favors for opportunities, and those women who refuse to cooperate are sidelined from the industry at the instance of powerful men. The second is discriminatory practices against women and lack of even basic facilities. This report has facilitated a long overdue discussion on the lack of gender equality for women at the workplace. The brutal incident of the rape and murder of a doctor at a hospital in Kolkata also reinforces the need for this conversation. The next part of this article, Culture of Assault. The concerns raised in the Hema Committee report are disturbing, yet are not surprising. They are an extension of the problems women face in a conservative, patriarchal society such as ours. Women are burdened by stereotypes and expectations about how they should behave. This is why it is problematic to consider instances of sexual assault on women as isolated. Viewed this way, rape must not be considered only as a crime committed by a bad man, but as a culmination too of the social practices which deem the consent of women to be practically irrelevant. A rigid individualistic approach to sexual assault often distracts attention from this reality. Ranging from what to wear and what friends to have, individual choice is too often stolen from women. Rape is the crudest manifestation or the most heinous manifestation of this approach, not considering women as persons of autonomy and dignity. The normalization of objectification and gender stereotypes has a central role in perpetuating sexual assault against women. According to the NCRB or National Crime Records Bureau, 31,516 cases of rape are reported in 2022 in India, a reported rape in every 16 minutes. Workplace harassment is another reflection of this culture of assault. In the context of workplace assault, in Vishaga and others versus State of Rajasthan, which is an important case of 1997, a writ petition was filed to enforce the rights of working women against sexual harassment. A series of guidelines was prescribed by the Supreme Court of India, a unique kind of judicial legislation to prevent workplace harassment. These included duties on the employer to prevent assault as well as constitution of a complaint redress mechanism for aggrieved persons. It took more than 16 years thereafter for the legislature to enact the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. A notable feature of the legislation is that it provides for the constitution of an ICC or Internal Complaints Committee, which can be approached by the aggrieved women. The definition of workplace in Section 2 Clause O of the Act is broad enough to take in the film industry as well. The Justice Hema Committee report has, however, indicated that the ICC is not suitable for women in the film industry. It is argued that there is a likelihood of the abuser or the employer influencing the ICC members. The committee therefore pleads for an independent forum constituted by the government to deal with the problems faced by women in cinema. However, this is a problem that any ICC faces and is not unique to the industry. While additional safeguards of accountability might help alleviate or lessen the problem, the suggestion to completely overlook the complaints redress mechanism formulated by a parliamentary legislation seems unwise. Next part of the article is registration of crimes. Many have questioned the lack of a registration of crimes pursuant to the committee report. They ask why an investigation is not initiated and why the accused cannot be brought to justice. The concern is sensible. The report is a modified version which redacted or reduced the names of survivors and the culprits. Masking the name of survivors is done in recognition of the principle of survivor anonymity, a well-accepted norm in criminal jurisprudence on sexual assault. Anonymity will remain intact during the investigation and prosecution as well. In Nibun Saxena versus Union of India 2018, the Supreme Court explained the importance of penalization of the discourse of the name and the identity of the survivors of sexual offences as mandated in Section 228A of the IPC, which is now reiterated in Sections 72 and 73 of the BNS or Bharatiya Nyaya Samhita. Section 222A of the IPC deals with disclosure of identity of victim in certain offences. These certain offences include, of the IPC, Section 376, which deals with punishment for rape, 376A, which deals with rape resulting in the vegetative state of the woman or victim, 376AB, where the woman is aged less than 12 years of age, 376B, which is rape committed by husband on wife during the time of separation, 376C, which deals with rape by a person in authority, 376D, which deals with gang rape, 376DA, which is the rape of women less than 16 years of age, 376DB, which is committing gang rape on a woman aged less than 12 years, and also 376E, which is providing punishment for repeat offenders of rape. These are now covered under different sections of the BNS or Bharatiya Nyaya Samhita. Back to the article. Since the provisions are substantially the same, the ratio of the judgment in Nibun Saxena would govern the field. In the judgment, the court said that the object of the provision is to protect survivors from hostile discrimination and future harassment. This being the law of the land, the Kerala government must take a proactive role in the matter after sensitizing itself in the matter. The right to privacy is an integral part of the right to life under Article 21. This was said in Puttaswamy 2017 case. The statements were given by several victims in the belief that this anonymity will be maintained. The right to decide whether to pursue a criminal case does lie with the victim. It is true that in our criminal justice system, the state initiates prosecution against the accused, arguing and conducting the case on behalf of the victim. However, even if the state investigates the crime, it becomes quite difficult to prove a crime without the cooperation of the victim. Why survivors are often reluctant to pursue complaints in the case of sexual assault is important for us to recognize. A society which looks at survivors of sexual assault with misguided empathy and disgust instead of support and trust probably has no moral standing to demand that the survivor must necessarily launch the complaint. We all share collective responsibility for manufacturing this status quo. Moreover, trials in sexual assault cases take years to complete, which are attributable to the high degree of judicial pendency in our country. Bear in mind that the Hema committee was formed after the sexual assault allegation against a leading Malayalam cinema actor, the trial of which is not yet completed. Survivors also fear potential retaliation from the abuser and others in terms of refusal to give them work and being branded as problem makers. The concluding part of this article, structural reforms. The accusations in 2017 against Harvey Weinstein, the American film producer, had eventually led to the Me Too movement, #MeToo movement, which received global attention. The findings in the Hema committee report must pave way for the structural reforms for which the government must take an effective lead. The difficulties faced by women in the industry, particularly those in the lower strata, as opposed to the lead actresses, deserve acknowledgement. From the lack of adequate sanitation facilities to hostile bias, every issue needs comprehensive study and resolution. More importantly, the report will accelerate Indian women's struggle against workplace discrimination by equipping her with an emboldened awareness.